Good afternoon, everyone. Thanks for coming by at the very, very end of GDC. Happy to see so many people here. This is Legal Battle Royale, Not Boring Edition. And put bluntly, the idea is to go through hot and interesting topics in the game industry from a legal perspective, but in a way that's going to be useful to non-lawyers. So can I get a sense of who in the audience? How many lawyers do we have here? Okay. Oh, uh-oh. Wow. Uh-oh, sleeper agents. But for those of you who are non-lawyers, I assume that most of you are here because you have either some questions or you want to get a better sense of how legal issues are going to impact decisions you make as developers or publishers. So I think what we're going to do is maybe take about half the time to go through a couple of topics that we consider pretty interesting and that are currently kind of hot legal topics that we think there's something important to say about. And then about halfway through, we'll switch over to audience questions. And I've got a million things we could talk about. So if there aren't a lot of burning questions, we can always go back to that. So I think I'm going to go through and allow everyone to introduce themselves. I'll start. My name is Chris Reid. I'm in-house counsel for Tilting Point, who's a mobile game publisher and growth marketing company in New York. Woo! And then we have Stephen.
Right. I'm Stephen McArthur. I will stand up this one time so that everyone on that side of the room can see me. Hello. My name is Stephen McArthur. I run a small law firm of 4 or 5 attorneys in Los Angeles, and we work with video game developers.
I'll also stand up and wave to the other people with crazy colored hair. I'm Ibrahim. I'm with Interactive Entertainment Law Group. We are based in El Segundo, California, which is in Los Angeles, and we represent about 300 companies, publishers, and developers, all exclusively in the game space.
My name is Greg Boyd. I am partner at Frankfurt Kern at Klein & Sells. We have office in New York and in Los Angeles. We're a media and entertainment firm in general, but my group is mainly interactive entertainment, and I do about the other half of my time in advertising.
Cool. So I think before we get started, there's two things I want to do. And the first is that in the interests of helping bridge the gap between lawyers and humans, I've gotten some visual signifiers. A lot of times people say, hey, can you give me that contract in like human readable format, which I've always taken a little bit of offense to because it implies that lawyers aren't humans. But
we're not.
Oh, yeah, not fully human. We're more
totally
human than human.
By the way.
So the idea is going to be that a lot of questions we're going to answer from a legal perspective, giving sort of an angle from our legal knowledge, but then there may also be cultural or non-legal aspects to the question. And I want to be really distinct as when we're talking as lawyers and when we're speaking as humans. So to that end, we've got 2 sets of hats so that we can literally wear our lawyer hats when we're being lawyers and wear our human hats when we're pretending to be human.
Wait, pretending?
Yeah, emulating.
You're giving away the game.
Do I get to keep this because this is awesome?
Oh, absolutely.
Oh, this is badass.
That's the guess. There you go.
Chris,
Best swag of
totally
GDC.
clash with my
I
hair.
know, I'm sorry.
It's okay.
I'm sorry.
You can
I'll
hold
still
it
wear
up.
it.
You don't have to wear it.
I'll still wear it.
All right, I'm gonna start. I'm gonna start as lawyer.
What are you going to be? You're going to be
I'm going with the human.
And the second thing I
I'm on
want to
team
point
humans.
out is, and you've of course heard this if you've ever dealt with lawyers, but we do not represent any of you. Our firms are not representing you. When we speak, we're giving generalized information about legal issues and not specific legal advice that you should go home and act on. So I know that there will be questions where it's like, well, my friend has this really specific scenario. We can tell you generally about it, but it's not legal advice. And I think it also is important to state that we all work for firms or for companies, and the opinions we're going to give do not reflect those of the companies we work for or any of the clients. And there will be certain issues upon which some of the panelists cannot speak because they may be working with people involved in those issues. So if someone is, the human hats will be helpful there, but even then it's, so if someone gets a little cagey, it's probably because they're working, we're talking about one of their clients. Okay, so with that, I'm just gonna jump around to a couple of issues that I think probably are top on people's minds that they've heard about. And I think we kind of have to start with dancing. I think everyone's aware that there's been a series of lawsuits leveled at Epic for dances that you can buy as emotes in Fortnite, and they're not the only company that has that has emotes that may be based on identifiable real-world dances. But I think I wanted to throw it open to the panel. From a legal perspective, how likely are any of these suits to succeed? And can we maybe just give a quick primer on why you think that, and how the law in this area works, and what the implications may be for any games using emotes, since mocap is becoming more and more common in games?
Sure. So I'll start, and I'll let you both, of course, jump in and interrupt me as you please. So this issue is very, and I will be wearing my lawyer hat for this, for sure. Okay, so the issue here is what is protectable. So what happened, for those that don't know, is there are these dances that have been popularized and sometimes created by certain people. They're often simple dance steps, two or three moves, and people become known for them. And Fortnite, you can buy emotes in Fortnite such that you can make your character do that certain dance. And in every situation, they've renamed the dance. So for example, this rapper 2 Milli created something called the Milli Rock in 2014 and popularized it.
Can you show us?
Can you show us?
I don't know it.
Okay.
Like, that's why I was asking you. I can do the
You didn't
chorus,
pay
but
for the
I don't
emote.
wanna get one.
I did not pay for the emote. But so he popularizes this, and it becomes known as the Milli Rock. So in Fortnite, they rename it to, I don't remember, the something else. The Fresh is what they call it, I think. But they don't call it the Milli Rock. And they don't use 2 Milli's name. They don't use his likeness. All they're using is his dance moves. So this begs the question, if they steal his creation from him and they use it to make money, what cause of action does 2 Milli have? How can he be reimbursed for this?
Cause of action means right to sue someone.
Yes. When you sue someone, when you file a lawsuit, you have causes of action, such as breach of
It has
contract.
to fit in a certain bucket in order
Yes.
to. You can't just sue someone because.
So,
Wow.
yes. So the interesting thing with
That's not true.
so one of the first things they went to is copyright law, because copyright law is supposed to be there to cover creative works and creative expression, such as music and books and poetry. Source code, even when you draft your source code, that is covered by copyright law. And copyright law, the statute specifically says it covers choreography. So it would seem at a first glance that perhaps they can sue for copyright infringement. The problem is, the short answer is no, they can't. And even though they can sue for it, but they will not win. And the long answer is because the Copyright Office and the federal courts have been very, very clear that you cannot get copyright protection for a simple dance step. So
you need like a ballet.
yes, you need the actual legislative history talks about a 22-minute ballet. And that is what you can get copyright protection dance over.
Specific.
Yes,
Like,
it
it's
is.
pointlessly specific.
It is.
Like 22 minutes. Why not like 15?
Because
or 30?
they gave an example of a particular ballet that happened to be 22 minutes long, is I think the issue. And so there have been other lawsuits in the past. There was a lawsuit in the early 80s over the electric slide, which was this 18-step dance move. And the creator of the electric slide started suing people who were doing the electric slide because they were doing it wrong. And that
is awesome.
And that pissed him off that they were doing it wrong. So he started suing them and lost. And so we have this and as you know, the law looks at what's called precedent and case history, what happened in the past, because it's very important that we are consistent. It's often more important than being right, is just being consistent, so that people know what they can do and whether they're going to get sued or not.
This is called precedent.
Precedent, yes. So the answer is that they will probably lose their copyright lawsuits, although they have a couple of other interesting causes of action around right of publicity.
Trademark, things like that.
So
Right.
right of publicity being your right to not have people put your face on a cereal box without your permission,
Right.
essentially.
Unfair competition would be more accurate than trademark.
So it's a right of publicity issue which differs state by state. So the issue with right of publicity is and this is a huge issue in video games, is you cannot use someone's, and we'll probably talk more about this later, you cannot use someone's likeness without paying them, generally speaking, because it's an economic right. And what is your likeness? Your likeness is your image, your name. In some voices, if someone has I think Barbara Streisand won that her voice was her likeness. So to win these cases based off likeness, it is very difficult because they have to argue that the floss, for example, the kid that does the floss. If you see anyone do the floss,
I want to see the floss first of all.
you have volunteered.
I'm old.
Chris.
I don't know, something like this.
Yes.
You can't see it, it's behind the
My
thing.
niece was teaching me that one. It's the one that goes like 1, 2.
Yeah, I think you have to go like in front and behind.
Yeah,
Yes.
it's like,
It's very complicated.
Okay. My like 9-year-old niece was teaching me this at Disney World.
We have some volunteers in the back flossing. It's amazing.
There we go. Perfect.
So the long story short is this is going to be an uphill battle for them to win because they have to establish that when you see this dance, it just has become merged with their likeness. It's basically a photograph of them. And
So-
it's just going to be really difficult for them to win that argument, I think.
So I have one thing to point out, though, on that particular right of publicity issue, is that, so for example, the Carlton one, the only dance I actually know out of all of these different cases, the Carlton dance is actually owned by the studio that did the Fresh Prince of Bel-Air. So the issue is more about preemption, because the copyright law would preempt the right of publicity that Carlton has. So
Yeah, there's a lot of issues, and preemption is another one. These guys have a lot of reasons they're probably not going to win their cases, but that pulls up another issue.
So, speaking as a human now, what does this mean if I'm a publisher or I'm a developer? What, practically speaking, given that there's a lot of sort of cultural artifacts like dance moves that sort of blow up, become viral, and that a lot of times people want to reference in their games in one way or another. What does this mean for developers in how they're going to approach thinking about the risk of doing things? Does that, what you just said, does that mean, sure, fair game, should we just jump in and grab whatever we want? Practically speaking, does it make sense to approach people who are creators of these, and how do you even determine who gets credit for that?
ask your lawyer.
Right, so...
I mean, at the end of the day, it's a case-by-case basis, right? We're not talking about something that you can just give a blanket answer to on this one.
Yeah.
Because it's going to come down to how much are you using, who are you taking it from, how big, like how much of a mark are you going to be on the radar in terms of liability.
Look,
Go ahead.
I'm gonna do the human hat for a second. This is the way I explain it to people when they come to me. So the more successful your game is, the worse cases people will bring against you. And the less people play your game, the more you can do anything you want. Okay? Now, you can come to me and I can tell you what the law is. And here's the thing, and I'm not talking about, in fact, I can't discuss this particular game, let's be 100% clear, because we do an enormous amount with that particular game. But in general, if your game makes $100 million a year, you are going to have to be beyond spotless or else, and you're just going to have a ton of things that have nuisance suits. And at the same time, if you have a browser-based game that your grandmom and your aunt will play and your second grade teacher, put Kim Kardashian in it. Put a buy now for heroin in it. I mean, the thing that I'm not actually.
You might want to remove the human hat for that one.
No, just the human. And obviously not connected to real buy now for that. But I'm just saying you can take a tremendous amount more risk when you have a small audience. But by the time that you become very successful and think about a top 20 publisher, things have to be ultra buttoned up and things have to be conservative necessarily. And there's nothing you can do. You're going to draw crappy cases and you're just going to have a budget for that.
Yeah, and this is, I think, being extremely successful, there is just a tax, and people suing you is just a tax on success, and there is no way around it. I have clients asking me, how can we avoid getting sued by patent trolls? How can we avoid patent infringement?
Don't make money.
Well, exactly. The answer is you can't. At a certain point of success, you will be sued, and you will be sued for patent infringement, and there's literally nothing you can do to stop it. And
That's all I had to say. Like, don't make money. That's pretty much the only way to not get sued.
And the interesting thing is there was many other video games doing this exact same thing, yet they weren't sued. Only Fortnite was sued, even though many other companies were doing this.
I have a question about. I'm going to put on my human hat because this is a legitimate question about World of Warcraft. Like, and I say this as somebody who played World of Warcraft for years. There are all sorts of dances. They were all sourced from fairly popular dances. On top of that, like, just blanket theft of general IP like Dark Crystal. Like, there's an entire race of creatures in World of Warcraft, which is a straight ripoff from the Dark Crystal. And so you kind of have to wonder, how is it that a company like Activision can borrow this material without the liability that, for example, Fortnite is seeing?
Well, I think one issue that is going on is that I think a lot of it is actually driven by this law firm. So there's been a lot of these lawsuits against Epic, and they're all based on the same thing, and they're all brought by the exact same law firm. And there's this new law firm, and I think it's a little bit of a disservice because I think Fortnite or Epic is at the wrong place at the wrong time because this law firm wants to get their name out there, and they're using these lawsuits and these celebrities as a way to almost market themselves, and it's
They're not going to be very popular with other lawyers in this space. I'm just going to put that out
they
there
are
right now.
very unpopular with lawyers in this space right now.
So speaking of being careful as you get more successful, and I think the message here has been that, yeah, you can't stop people from suing you. The best you can do is anticipate which things might be an issue and make sure that your house is in order. Another area where people have to be very careful, and it's also garnered a lot of attention in the last couple of years, is loot boxes. People love to have opinions about it, both as would-be game designers and as would-be legislators, and so there's been, I think, a lot of discussion about it, but also a lot of potential and actual regulation in different countries and in different states. Where do we see this shaking out? I mean, if I'm a company that wants to use loot boxes, or let's just open it up to gambling in general.
I think we need to be very careful about that line. Please, let's be very
Well,
careful
okay,
about
so
walking
let's
that line.
start with the question of where on the line do loot boxes fall, and that comes into two questions. One, looking at current legislation, is it clear whether they may be defined as one or the other? And then, if you dare to opine on where that line should be, I'd be happy to hear that too.
Okay, so gambling requires, under almost every single state's law, at least three things: consideration, prize, and chance. And consideration is something that you give, usually in the form of cash or currency, in order for the right to participate in this chance to receive a prize. Real simple way of explaining what gambling is from a legislative perspective. And that more or less reflects what we see in the US and what we see abroad for what gambling is. Now, where loot boxes become tricky is, well, a few things. First, let's look at the question of consideration. Well, what are you paying for it? If you're actually paying a cash price for it, that's one thing, and yes, that's pretty clearly well defined. But then you look at a game like PUBG where you're not actually paying cash for it. The currency you're generating is from time played, right? At least that was my experience playing or getting loot boxes from PUBG. If that's the case, then what is your consideration? Does it qualify as actual consideration under the particular statute or whatever in question? Then there's the question of chance. And generally speaking, loot boxes are going to incorporate an element of chance unless you're guaranteed to get certain things in that loot box that you're purchasing. So like whether or not there are odds associated with the loot box or not are going to be an issue. And the final thing is obviously a prize. And the issue with the prize is that the law isn't always really clear on whether or not a prize needs to have cash value or not. So if the prize that you receive isn't convertible to currency in some form or can't be sold, then does it actually have value enough to qualify as a prize? So we really actually do have to be very careful about whether we call loot boxes gambling or not.
Right.
And honestly, the biggest issue with loot boxes from a regulatory standpoint, at least as far as the FTC is concerned, has more to do with consumer protection and keeping kids from spending like $3K on their parents' credit card. And it's really just about informing the public if there are odds and stuff like that.
And this reason she's talking about being able to sell it is one of the reasons that when you read a terms of use, as I'm sure you always read the terms of use of every video game you play and download.
I do.
I draft them, and I don't think I've ever read one. The terms of use and the...
I read them because I draft.
Yeah, I copy paste ones
Yeah,
when I think they're cool.
exactly.
Like, ooh, this one's interesting. I'll save that for later.
You never have time to play anything if you're reading them all. But there's terms of use, buried in every one. It will say things such as, you don't own any of this. This software is all owned by the company. We can revoke it anytime. Importantly, you cannot sell this, right? So even though technically, even if you maybe could go out to a third-party marketplace, the terms of use in the EULA says you cannot. Like we disallow you from selling this. If we figured out you sold this, we'll ban you. And this actually became very relevant in a case where the judge said there was no cash value to these loot boxes because even though they theoretically could go out on these third-party websites and sell them, I think this was the Big Fish case, it's against the rules, and they don't encourage it. There's no official way to sell these, and it's against the rules and the terms of use. And so they got that case dismissed.
So where do we think, so that's a good explanation of sort of where we are right now with loot boxes. But given that this mechanic is something that seems to be, you know, it's useful in a lot of games, and people can debate whether they like it as a game design thing, but where do we see, if we had to predict, legislation and regulation on this going? Because obviously right now, yeah, it's quite complicated. We're trying to fit a new phenomenon into existing laws that were designed for casinos and slot machines and that sort of thing, and you know, it's not clear always where it fits. But I mean, if you had to guess, you know, is it going to continue to be a patchwork and a mess, different states, different countries?
I'll do it. Yeah, so I have a few, well, I don't know which one this is. This is kind of lawyer thoughts. So, okay, I think there are two paths on this decision tree. So one is less regulation of the status quo, right? Like, I would like it if, and it sure would be nice if, and I mean it for all of us, the home team, the game developers, and it's not bad for the consumers either, is if the rule was, and the rule pretty much is now, it's like, with some exceptions, if you don't have a cash out mechanism, you're okay, right? But then to the extent that it becomes more regulated, I hope it's not more regulated than we do sweepstakes contest and promotion. So, and look, I know that sucks too, but the thing is sweepstakes contest and promotion has state laws, but we have a consensus. A lot of it's about disclosure. I'm not wishing for it. You know, what I wish is something like we have right now, but I hope it doesn't get, I hope that's the far right boundary, right? I hope that it doesn't go beyond that and, you know, cross over into gambling regulatory, which is much worse. But to me, right now, if it's not harming children, if there's a special disclosure for under 13 games, then I think it's in a pretty good spot, especially if you as game companies, this is one of the things I say to people just quickly in closing on this, is that you can solve a lot of this on a customer service level. If a mom calls you and says 17-year-old boy, girl, whatever, spent $3,000 on my credit card, you make it right there on the customer service level, and you don't eat that money, and maybe you put a stop in there, like they can't spend more than $100 a month or something, right? There's something you can do on a customer service level, and that's going to save us from some regulatory intervention, because then that mom or dad's story doesn't become a news story, which is what a politician reads in an election year and decides this is some new kind of, you know, save the kids mom and apple pie legislation that would be really easy to be elected on. So that would be the ideal for me.
Yep, and you know, following on that, and we see this in copyright too, or we see this in censorship in general, with violence in games. Generally, the best way the industry can insulate itself from regulation is to be responsible, like to actually exercise some level of social responsibility with how you engage with your customers. And that is as much true for gambling and loot boxes as it is for violence in games or anything else. The more we try to say, well, freedom of speech, let's do whatever we want, you know, we can say and do however we want, we don't need to be responsible for it, the higher the likelihood that eventually some government is going to come in and say, oh, yes, you do. Like, you need to be responsible for this because obviously you are incapable of regulating yourselves. One of the things that the video game industry has really benefited from are programs like the ESRB and the ESA that help us self-regulate. The more we get to self-regulate, the better off we are in terms of being able to service our customers and give them what they want without customer interference or without government interference, because governments are really terrible at economics and customer support in general.
Gotcha. I'll just end this. Maybe the one time I put on my human hat for tonight. The two things I will say that it may not be technically required, but generally make loot box type experiences less evil is when game companies, show you the odds, right? So if there is some chase item out there that everyone wants, and there's a 1 in 10,000 chance of you getting it, so people are spending $1 or $2 to buy these loot boxes that look for this awesome chase object. You know, if the consumers know there's only 1 in 10,000 chance of getting it, that is important, and I think that's something people should know, right? If when they're spending money on loot box, they should know what the odds are. And the second thing is, you know, usually give them, if they're going to spend $1 on your loot box, give them $1's worth of product in there, not 10 cents worth of product.
Yeah.
Also, just to put that in, if you're distributing in Japan, you have to do that one way or the other due to
Right.
gotcha regulation.
Right. Many countries do require that already.
So I want to move over to another area that I think has kind of exploded in the last 5 years in the game industry, and that's streaming and the rise of sort of influencers as a very dominant force. So, Apex Legends dropped with almost no fanfare and basically rode to 5 million plus, installs on the back of A, being a good game, but B, a lot of prominent streamers playing it. And it then came out. Well, came out makes it sound like it was a big secret, but no surprise, some of these streamers were paid quite substantial, sums in order to stream it at a specific time, all on the launch days. I think Ninja was paid $1 million or something like that to play it for like 8 hours. So I want to ask a little bit about what we think developers and publishers, if they're the ones handling the marketing, need to understand when they're interacting with influencers, any kind of marketing or advertising. What kind of pitfalls are there? Can I just hand over a bunch of money and say, hey, play my game, say XYZ? What do I have to do?
Yeah. So I'll start this off and go real quick. So the current guidelines for influencers are the same thing for people in video games as there are for people that are selling shoes, right? The Federal Trade Commission has come out and said if there's a material connection between your company and the influencer, then that influencer needs to disclose the material connection. This is where you see hashtag ad or hashtag sponsored or hashtag, your game ambassador, or the streamer says, I'd like to thank game company for their support, et cetera. The disclosure has to be clear and conspicuous, and the disclosure has to fit the medium and travel with the medium. So there's a lot of complexity to unpack there. We don't have to do it right now, but they are supposed to say something, and they are supposed to disclose. And here's the question, or here's the way that you should think about it, to the extent that you're asking the question, you're making games and you're asking the question, or to the extent that you're an attorney and people are asking you the question. If your creative folks come to you and say, hey, is such and such sufficient, in the tiny little mouse voice? The answer is no. The answer is no, because that's not clear and conspicuous, right? So that doesn't meet the FTC guide. Anyway, we can chat more about this. We now have hundreds of FTC letters saying what's sufficient, what's not sufficient. So 2 years ago we were guessing. We don't have to guess anymore.
And if I screw this up as a developer or a publisher, what's the result going to be? Who's going to sue me or fine me, and who should be worried? Should it be the influencer? Should it be the developer? How should they think about this in terms of risk?
This hat. Okay. So what would likely happen, if what's happened in the past continues to happen, is the brand, the publisher, the video game publisher, or the developer would get a letter from the FTC that would be published. And it would be embarrassing. The influencer would also likely get one. Now, the fear is at this point that there would be some combined regulatory business that would occur, and what's been letters in the past will now become fines, because they could look at us and say, we gave you guys hundreds of examples. We have FTC cases on disclosure. There was Machinima case was a case on disclosure. The Sony Vita case with the hashtag game changer was astroturfing, which is like fake grassroots, which that was essentially also a case on disclosure, because if they had properly disclosed, it wouldn't have been astroturfing. So they could say now that you guys have had years of warning and years of understanding. The stakes are going to be higher. The thing I do want to point out that's a really big deal that should be unambiguously described is if you are the party paying the money, meaning you're the ultimate brand, you're the developer, you're the publisher, you cannot absolve yourself of responsibility by putting it on the influencers or putting it on your marketing agency. The regulators have said outright it has to be you that is responsible for policing.
And
Even if it's in the contract.
Well, this is going to be a little bit of both. The reason for that is because ultimately the party paying the money is the one benefiting the most from the advertisement. from the endorsement. Another thing that, because I actually did a talk on this with Online Performers Group and some other people at PAX last year. One of the other things that I hear from a lot from influencers is, well, they gave me this for free, but it's not money. Like, they didn't pay me to do the ad, or, you know, they gave me, you know, this headset to test so I can talk about it. Do I have to disclose that? And the answer is yes. You still have to disclose it, because unless you actually paid for it yourself, you are receiving some kind of benefit, whether it's financial or otherwise, and you still have to disclose that you received this. Now, how you do that in a stream, like, you know, we have that hashtag ad and whatnot. We have the 30, okay. So the hashtag thing is great for Twitter and whatnot, but when you're running a stream, how do you do these disclosures? And generally, I think, like, you know, the FTC has written guidelines on this as well, and it's generally like, you know, if you're doing a super long stream, maybe once every couple of hours. If you're doing like a short 1 hour stream, maybe at the beginning, and maybe have a card at the end, disclosing the fact. So.
And I'll say one other quick thing about streaming. Another thing I'm seeing more of now are transparent badges, especially if you are paying a streamer to stream for 2 hours, you know, early access to your game. They come up and they say, thanks, game company, for giving me early access to this level. Really excited to be playing it tonight. And then there might be some kind of transparent badge or something like that. The key is not one click away. If you're one click away, you're hosed. Don't do that.
Wait, could you explain that?
Sure. So one click away is like, people used to ask or were curious, well, what if I go to more, and then at the bottom of more, there's some disclosure? Or what if it's in the about page for the streamer? Yeah. And in fact, I don't want to name, you guys can look into this or talk to me after. There's one particularly embarrassing case that all the way at the bottom of a whole lot of lines of more, it actually wrote something like, I can't believe that you read this far. This is so embarrassing and unlikely, but this video was sponsored by such and such, and that was reprinted in the FTC opinion against this party. It's like, how could you allow your influencer to sort of mock the process like this? Yeah, so don't be that person.
It's a human hat for this, because this is a general rule for streamers, for game developers, for everyone. Don't be a dick.
That's actually a general rule for everyone.
Yeah,
I would hope.
Audience.
Yeah, so I wanted to move to audience questions, though I do feel like, what do you think? Should we dive into privacy, GDPR? Well, I think it's important to talk about privacy, because I think it's connected to a lot of things, but I don't want us to take like 20 minutes, because I want to get to audience questions. So the last like sort of preceded topic that I'm going to talk about is privacy. You may recall around May last year, you got approximately 400 emails that said, we've updated our privacy policy. And you may have scratched your head and said, why am I getting these all in the same week? And the answer is that the EU, the answer is Mona. She drafted most of them.
all at the same time, because the clients all came within the same like 3-week period right before May 31st, 2018.
So what happened was the EU finally put into effect a sweeping privacy regulation that sort of altered the responsibilities of anyone on the internet collecting personal data from people in the EU, which is a lot of people. And so everyone scrambled to kind of figure out, oh, what do we have to do to become compliant? Because some of the potential fines were huge. Now the problem is, this is a sort of a government regulation where they said, here's what might happen, but of course nobody knew whether they were going to be mean about it, whether they were going to be, chill about it, for lack of a better term. And so it has a lot of far-reaching implications. For instance, Tilting Point does free-to-play mobile. We spend a lot of effort making sure that our technology is on point to separate out personal data and do all of that. And it's in games in general, even if it's a single-player game, you're generally collecting quite a bit of data, and that data can be useful. And some of it is a name for an account or things that can identify a person. So, and this is especially interesting because just earlier this week, Google announced Stadia, which is their, is it Stadia or Stadia? I don't know what they're called. Stadia, yeah, that's what I thought. And this is going to be interesting because Google is known for having quite a bit of information about you. So it raises some interesting questions as to how they might, combine that data with the data they're going to have of your every move within games as you stream it. So I think, if anyone wants to take sort of a very top-level explanation of Greg does not. Of why anyone should care about it, and just very, very generally, what are the new obligations that developers and anyone that's using data, which is everyone, what new obligations do we have?
So as to why you should care, I will put out a number for you, $57 million. That's what Google was fined by the GDPR Commission for violating GDPR. Chances are this is going to continue to be litigated. They're going to fight it back and forth, but that's $57 million most of us don't have. So just to put that out there, GDPR Commission is not afraid of fining as much as they want. They have some benchmarks for that, but they are taking it very seriously. A couple of high-level points on this. The entire point of GDPR, and the easiest way to explain it, is private. Like, what they are trying to accomplish is they want to make the internet as an industry, privacy by design. They want companies to sell privacy as a service. They want this to be incorporated in how they service their customer base. So they don't want data to be the selling point for the business unless their clients are unless their customers are very aware of that fact. One of the biggest issues for this, and one of the reasons as to why Google was fined $57 million, which probably isn't actually that big of a number when we talk about Google. Fair. The reason why Google got into so much trouble, or one of the many reasons as to why Google got in so much trouble, is this idea of consent. And when you need to ask people for permission in order to collect their data, your privacy policy is no longer a contract, and that is something that you need to be very aware of at this point in time. If at any point you thought, if at any point you had an accept or do not accept at the end of your privacy policy, get rid of it now, because blanket consents are not allowed. You have to ask consent at the time of collection for that specific point of data.
Yeah, and to clarify, that GDPR is talking primarily about what we call personal information. So, totally anonymized data is not so much the issue as any type of data that would let me figure out who you are in the really real world.
But their definition of personal data is extreme. It's not just
very
your
broad.
email address, date of birth. It can be your IP address. I mean, it
So,
can be.
so the tricky part about it is that it's not just any information you collect. It's any information when taken with anybody else that you work with could possibly identify that individual in some context. That is considered personal. It's bullshit. It's huge.
Well, hold
I
on.
stopped myself. I said bull.
Well, no. Oh, the cursing wasn't my issue.
No, I was just like, one day you might find yourself in front of a regulator and they play this back.
I would say that maybe the argument is that the execution and the way that it was drafted is perhaps not clear or helpful, but perhaps they are aiming at very valid goals.
So I was gonna put the human hat on and just say this entirely non-legal thing. The statute has its own website. If you print it out, it is 500 pages. It is the modern Necronomicon. So you can, if there's something in your life that you think you should get some help with, it is GDPR. Okay.
Yeah.
Fair. All right, so I think at this point, because I think GDPR, no matter how user-friendly we make it, is going to make people's eyes glaze over. I'm going to throw it open to questions, because I think maybe that will be a great way to sort of see what people in the industry are actually concerned about, and hopefully we can provide some clarity on how you should be approaching it. So, yeah.
Hi, thanks very much. This is a very interesting panel. I wanted to circle back to the loot box conversation, but use it in the context of blockchain.
Okay.
So blockchain technology, especially non-fungible tokens in blockchain.
CryptoKitties is what you're talking about.
I'm actually legal counsel for CryptoKitties.
That would explain it. Okay, hello, nice to meet you. Lots to talk to you about.
One of the questions that I have had is how to manage the gaming mechanic question when, by its very nature, non-fungible tokens, you were saying, look, the way to solve the problem of loot boxes is make sure you can't cash out. Guess what? NFTs are based on being able to have secondary market sources. So, how would you handle it?
It's a very specific legal question.
I would say, well, I would say to a certain extent, again, it comes down to those three questions, right? Consideration, chance, and prize. So the question is really that chance, I think, when it comes to non-fungible tokens, because you are effectively guaranteed to get an entirely unique token. Based, like, from my understanding of CryptoKitties, whenever you create one of those non-fungible tokens, which is basically the kitten, right? It's the cat you actually get from the game. Those are each unique. And those are each special. So by virtue of the fact that they are all distinctly unique and distinctly special, and therefore non-fungible in the sense that they cannot be exchanged for something identical, then they all share effectively the same value at base, because they are all essentially unique. This is me over-lawyering the crap out of this question, by the way. But that would be the argument. That would be the position I would take if I were counsel for CryptoKitties.
So I will also say, and maybe this is the human hat, I'm not sure, but to a certain extent, there's a lot of things out there that already meet all three of those definitions, or clearly each of those, yet are not illegal, right? So
Magic cards.
Magic cards, I mean, my example. You pay, God, I've not bought Magic cards since like 1999. It was like $3 for a pack of Magic cards. I don't know what it is now. $5, okay.
Get into it, man.
Inflation.
I played a lot of Artifact recently. But these are all, yeah, I know, it died very quickly. Anyway. You are paying money for something, and there's a complete random chance that what you take out of there. It is directly exchangeable for cash. I mean, Magic cards and are just directly exchangeable for cash. So this meets the entire definition. Why aren't these illegal? Isn't this a loot box? And yet they've been around for 25 years, and no one's ever gone after them.
So much fun.
Just because you're doing something that meets the criteria does not mean anyone's ever come after you.
Yeah, because that really comes down to the gambling question, right? It comes down to how are consumers using your product? How are consumers actually like playing your game? Are they spending a dangerous amount of income in order to get that specific kitten? And if not, then you're probably not going to be getting on anybody's radar on anybody's bad side.
Cool. Thank you.
But then Magic is so huge. I don't know. I can't explain it.
Magic is magic.
Maybe the regulators are, maybe they play.
And Nick Mitchell is excellent.
What's that? Oh gosh, we have two. Sorry, I didn't realize there were two
it's
whole
okay.
things. I'm sorry to this side of the room, by the way, that they put this in the middle. There was no way to. Yeah.
Well,
So.
great panel. I
Yes.
have a question about historically accurate games, especially if you're
Sure.
trying to preserve history of like our present.
Is that
times.
mic on? It
I don't
sounds.
think so.
Oh, can we make sure that mic is live as well, just for recording?
Yes, the question is about historically accurate video games.
Video games.
Yes.
Taking place in like
Oh, just get closer to it.
taking place in 2019, and you want to use maybe like trademarks, like logos
Sure.
of real corporations, real countries, real people.
Yeah.
Like it sounds totally illegal, but like
I think all three of us may have a lot to say about this,
Okay.
but it
Yeah,
really
this-
depends.
Yeah.
It's extremely context dependent.
Extricating myself from this one because this is way too much of a of that. It depends.
Well, actually, Mona, why don't you tell us about Red Dead Redemption and Pinkerton?
No, I'm not touching that one. I don't but no, oh God, that was silly. That was really silly.
Oh yeah, well, so this was an example. I guess this was not modern day, but there's a lawsuit ongoing right now. You guys may have heard of this, of Pinkerton versus Red Dead Redemption. That's not the name of the companies, but it's essentially the IPs at issue. And Red Dead Redemption is a sort of historically accurate Old West game, and they have Pinkerton agents in them, and Pinkerton sent them a threatening letter and said, "You need to pay us. You need a license."
By the way, Pinkerton, in case anybody hasn't played Red Dead Redemption, because I actually had to look this up. I didn't pay attention to who the hell Pinkertons were this bounty hunter company or agency that used to go around and pick people up. But I just wanted
It's
to
also
know
the
that.
best Weezer album.
Yeah, yes, it is. Thank you. The union busting. There's photographs of them with Abraham Lincoln. They're real historical figures. I actually just gave a talk on this last week with the GC of Riot Games, and it turns out he used to be a Pinkerton agent before he went to law school. It was really random. Anyway, so the point is that Pinkerton's going to lose this because you can, to a certain extent. There's something called nominative trademark fair use, And that is just one of many considerations to use. If you want to use a modern day game and you're getting Coke caps, and on every single Coke cap is a Coca-Cola logo, you're going to get sued and you're going to lose. If you use photographs in your game, or even architecture of modern day buildings, that could be covered by copyright. And if that's on the cover of the games, maybe that's not okay. If it's just incorporated in the game, like in Spider-Man, maybe that is okay. It's so context dependent.
And I just want, for fun, to just describe like how this actually works, like in real life. So you're going to make a game. Let's say there's 1,000 art assets in it that could be something else. It's not just generic, whatever. Let's say there's 10,000. Let's say there's 100,000. What those folks do are they send a spreadsheet to our firm, these guys' firms, and it has little miniature links to the art asset, and it has multiple columns about it, including where it was sourced from and whether or not it was modified. And then this one particular company that I'm thinking about, but a lot of them do a variation of this, we color code a column red, yellow, and green based on how it's used and what we think the relative risk is. Another thing we haven't discussed that goes into this analysis that takes, it takes months of attorney time to go through all of the assets is how litigious is the party. So, like those little tree air fresheners, those are some dangerous bastards. I'm just letting you know.
Lindsay Lohan will sue you.
Yeah.
Anything Disney, keep away from Disney.
I mean, I think to summarize on a practical level, though, you never know who's going to sue you. There are risks, and it depends on if you're a tiny indie where you don't make any money, so no one cares, and it depends on who you're using and how. So there are no blanket rules for this. So there's a lot of questions. So I'm gonna, for the next couple, I'm gonna ask that we try and keep it to like kind of a nice, pithy responses so everyone can get to ask their questions.
And I'm sorry in advance, because some of these, like that question, we could have a whole 1 hour talk on.
It will all be available outside afterwards, by the way. So, well, at least I will. Are you guys
Yes.
stick around?
For like 15 minutes,
Okay,
I got
cool.
a client meeting.
Okay, yes.
Okay, so this goes back to the issue of privacy, and it kind of goes beyond just the GDPR. Companies like Facebook and Fitbit and Google and so on, they've been dealing with sort of personally identifiable information for a long time. And they typically have formed a sort of an in-house review board of some sort, which is not just lawyers, but also user advocates and technical people and so on, who basically review the issues here and give a thumbs up or down as to whether this process should be implemented. This is sort of analogous to institutional review boards that you get in universities doing human subject testing. I'm wondering, is there any kind of structure or standard way of dealing with this within the games industry?
No. There's nothing standardized yet. Keep in mind, a lot of these companies came into this pretty late in games in particular. As I said, like most of my clients didn't come to me, even though I gave them notice on GDPR about a year ago or a year before. They didn't start even thinking about implementing any kind of consumer-facing documentation or their own back-end process until like a month before GDPR went into effect. So they are in the process of trying to establish a process right now. They haven't, most of the companies that I've worked with and even some of the bigger companies, with the exception of a few who, are owned by Google or Hasbro, for example, because it's a very well-defined process. Some companies have gotten there, usually the bigger ones, Microsoft, Wizards, whatever. But the smaller studios and the smaller publishers and the indies, no, they're still trying to figure this out.
Seems like there'd be good scope for an industry-wide.
That's a lot. I'm
sort of
sorry.
thing,
I have to seriously censor myself. I apologize.
Thank you. A quick reminder, by the way, after the talk, please do fill out the evaluations. They're very, very helpful to let us know how we did. So, any comments, concerns, et cetera. And they should send you an email about it. Yes?
All right, so I kind of have a loaded question.
Get really close to that mic, man. It's not good.
I kind of have a loaded question in a way.
Sure.
So recently, Civilization 6 updated their EULA. And one of the paragraphs, I don't have it on me, so I can't quote anything, but essentially allowed them to access and read any information whatsoever, not necessarily restricted to their product on our computers. And they updated that, and with the, expands into the question with a lot of games only actually provide you the EULA after you purchase the game. And if they update at any time, you're not able, unless you agree to it, you're not able to play the game that you purchased and spent money on.
Yeah.
If we take an example of Stellaris, that's $300 worth of game right there.
Yeah, that's two entirely different questions. The second one is like a huge issue we actually discuss. It's like one of these few kind of issues we discuss in law schools, these shrink wrap agreements. You've already bought a game, and then you've already bought some software product. You get home and open it. It says, great, you have now agreed to these terms of use. And essentially, if you can return it, if there's a method, I think, of returning it, then you are deemed, because you have not returned it, to have agreed to it. So I think as long as there's a method of returning it or refunding your money, then you are out of luck. And they said, well, sure, you paid $300 for it, opened it, but you could have returned it. You had, like in Steam, when you buy something, you get like 2 hours or something to play it and return it. So you're SOL. And
Well, and just really quickly on that. So in my experience, if you contact the publisher and it means a lot to you, you can get your money back. I mean, that's what I always advise them to do. Try it, see if it works. I mean, they may ask you to send the game back or not. And the second thing is, the reason it has to say something that looks like that is because the best cheat programs run entirely outside of the software. They're not looking at your Facebook photos.
Yeah.
I mean, they shouldn't be. Right.
Thank you.
So my question has almost nothing to do with anything you've spoken about, which...
Excellent.
I mean, yes, I really enjoyed what you spoke about because I have a consumer viewpoint about a lot of those topics that you mentioned. But my question is, I'm an indie, and we are a team that just came together as friends wanting to make something really cool. We all care about... Oh, I see an expression. We all care about the product and we all want to make it happen, but there has been almost no conversation as how we're going to actually make this a business.
Yeah.
And while I think everyone would agree that having legal protections and bylaws and all that would be amazing and would be helpful in the long run, I am concerned about bringing it up, because we haven't had this conversation at all, and I don't even know if other people in the team have even thought about it.
So,
go ahead.
I have a quick question just to kind of elaborate. Is this a hobby project, or are you actually planning on selling it?
We're actually planning on selling it.
Then you need to incorporate or otherwise form a business entity, because this is not a hobby.
Well, my question is more not, do we need to do this, more of, how do we broach this subject between a group of friends who, we trust each other, but this is still contentious and difficult.
So
yeah,
Yeah.
I agree. That's very well
you
said.
need to be able to
yeah.
have that
You do.
conversation.
So and also this is a situation I've seen quite a few times, is you guys don't incorporate, or you guys have just some kind of loose agreement, maybe some handshake agreement. There's 4 of you, each on a fourth of the company. You're gonna go forward. This is great. Well, in 6 months, one of you takes a job at Epic, and now they're out of the picture. 2 years later, your game releases. It's a huge success. Well, guess what? That guy that never really worked on the game, that took the job at Epic and never input anything else, still owns a fourth of your game.
We had this situation.
Yeah. So he owns a fourth of your game.
Council on this.
So
You better have
they've
an agreement in place.
Yeah,
Have an
and
agreement in place
I
that
too
shows what
have been
happens.
I've been on, I think we ended up settling this case, so it's not public, but for almost $100 million on a mega game that just nobody decided to talk to each other for a long time. Somebody just went away, and they thought they weren't ever going to hear from him again until that game started to make some real money.
I just realized that we
yeah.
actually had, that we were, the first time I ever worked against you on a
This
case.
is the
This
exact
case.
thing
This
we
is
did.
the question.
Yeah, Mona and I were opposite each other on a very contentious deal where this is literally what happened.
But the thing I'll say real quick is it's super common, but don't let it be common. If you guys are in here, I mean, get it done right. You'll be so happy you got it done right, even if the game doesn't work out.
To be honest, I can say this, I think for both of us, it sucked for both of our clients. Like, there was no happiness in that situation. So go ahead and have that conversation. If you're a team, if this is something you all care about, they should acknowledge that you are not selling out by actually creating a business if you plan on selling a product. You are always selling out if you're selling a product. That's what selling out means. You're selling something, right? Right?
And a good way to broach it in a way that won't be awkward if you feel awkward is to say, look, this is about protecting our friendship. Because, no, seriously, because I would say that the more you trust and like someone, the more important it is to have a contract. And the reason is that when you trust and like someone, many things will go unsaid because you trust each other. That's what trust is. And if you're dealing with a random stranger, you're going to know to ask a lot of questions, say, well, how exactly do the percentages work? But you're not going to know this. And by having this conversation in this contract, you have the confidence that your friendship isn't going to be destroyed if someone has a change of heart. So yeah, I would do it, and you'll feel better about it.
And they're going to breathe a sigh of relief when you bring it up and say, "Oh yeah, great, we were thinking this too. Let's get this wrapped up."
So there's a reason as to why I'm probably perpetually single, but one of the things that we do is
for a contract.
Is it the lawyer hat? Yes.
No, True, but I treat all relationships like they are, like I treat business relationships the same way I treat my romantic relationships and vice versa. And that is, you go through stages, right? Yeah, see, this is why I'm single. You go through these stages. It's not a zero-sum game, right? It's not about winning and losing, and anybody who says otherwise is full of it and does not know anything about contracts, and that means you, Donald Trump. When it comes down to it, you are creating a relationship, right? You are courting each other to find out if you have similar goals in mind. You are negotiating your values to determine what boundaries you establish in the relationship. And you have like a term sheet phase, which is kind of the honeymoon phase, and then you have the long term or the long form agreement, which is effectively like, your prenup. So at the end of the day, I mean, the business relationship is still a relationship, and the conversation isn't going to be that different.
All right, cool. So we've got about 5 minutes left, so now we're going to go to like lightning round because I really want to make sure everyone gets their question. Yes.
All right, thanks. I'll try to make this brief. My question is related to personalization, and it connects with both the gotcha loot box question as well as GDPR and privacy. Okay. When I think about monetization in mobile and sort of random-based monetization, we're entering a place where as Google and more players have more data, they're able to generate offers on a very individual level, right? And the bigger the data sets get, the more personalized the offers become.
Right.
What risks do you see for either publishers or developers from a legal perspective in terms of like how deep can you cut, or sort of, can you change the odds based on consumers? Can you, like, what could you do, and what pitfalls would you see as more players that deal with personalization enter the space?
Yeah, I think, I mean, at a top level, the use of the personal data, the sort of GDPR, and it's not just that regulation, but is sort of about either consent or having what they call a legitimate business interest. So that frames how you, what it is you're allowed to use someone's data for. And if they're not aware that, they say, yeah, sure, of course you can have my email and this, and you can track my clicks because I'm playing the game and that's how the game works, and yeah, I want to get special offers, that's fine. And if they agree to that, or if it's clear that that's what you're doing, that's fine. If you start doing this, but they think, oh, it's just everyone gets the same ads, that's an issue. I think as far as the changing of the odds, I would assume that it has to do with disclosure, and that there needs to be a way for them to understand. And I don't know if the fact that it's based on an algorithm and it could fluctuate 10 times a day, how do we disclose that?
I think if you find out that someone is vulnerable or not very smart or likely to make rash decisions, so you start offering them deals where they have terrible chances of winning, that seems really
predatory?
Bad. That seems bad.
Mean?
That's both my lawyer hat and my human hat. That seems like it's gonna go poorly. What do you think?
Yeah, I think lightning round.
Yeah, lightning round. All right. Yes.
Okay.
Thank you.
So on the disclosure and promotion type things, I work with educational institutions. I work with festivals, and we talk about a click away doesn't count. if a university wants to retweet stuff that's a student project being shown someplace, if a festival wants to retweet something that's by creators, are there concerns there of like they pay tuition, they pay submission fees for access to those PR machines, or is that not a concern at all? Awesome.
Not what they're paying for.
Okay, thank you so much.
Easy. Yes.
So when it comes to, this is more also about ties into communicating with the superiors. So for Rainbow Six Siege, what happened was there was a scandal of them censoring violence to, I believe, fit into the Chinese market.
Right.
And what happened was there was a lot of controversy surrounding that. And basically, there are different, what I'm trying to say that is that there are different costs to just being legally compliant, whether that be financial or reputational. Okay. How would you suggest communicating that to a superior who might be from a different culture or, all of that, to convince them that it is important to stay legal?
Yeah, it's the price of entry. Specifically with China, it's the price of entry.
Yeah. Well, that and never mind, I'm not going to say it, that would be offensive. Yeah, like with China in particular, things are extremely regulatory. Generally, you're working with a Chinese publisher anyway, so very few, I don't know of any companies that can get Chinese distribution without working for a company actually based in China.
As a
They
Chinese
tend to handle
person,
that
I
side.
give you full permission to say that. Like,
Oh,
you
okay.
are so right.
So the additional cost also goes to who you need to bribe to get it through the regulatory and licensing
Though
channels.
the U.S.
in China.
has laws against Foreign Corrupt Practices Act, so.
Well, we do, but.
Okay, I think we've hit time.
What an ending.
Everyone who's still in line, we're happy to talk to you outside and take your questions off the air. Thank you very much. Fill out your surveys, please. Thank you.